Hi, good evening. Oh, okay. Hi, good evening. This is Kenya Rockman, author and founder of the Child Support Hustle, the Reform Child Support Now movement. Hope everybody's doing well this evening. I'm not going to touch this thing right away until somebody says hi and I can verify that somebody's on here with me. Hope everybody's doing well this evening. Like I said, I'm going to try to do a video. Hey Marcel, hey sister, how you doing? Thank you for verifying that people can see this and I can see you. I can see the comments. I'm going to jump right into it. The voluntary side of child support. I made a video about this, but I didn't go into great detail. So I wanted to revisit this topic. And the reason why, because I think it's very important, especially with the recruitment now of new parents, because like I said, I wrote a blog about this, about a lot of children are now aging out, because we're talking about in 96, 98, when the welfare reform and child support reforms went into place, became enacted. So these children, like my daughter, are going in, turning 21, 22, so they're aging out of the system. So now they're looking for new recruits. So I thought this is very important, so the new parents or parents new to the system are aware of why the system is voluntary and kind of what their rights are. And why I say that is the most important thing. If this was not a voluntary system, everybody would be on child support. There's so much money to be made. They would just put people on child support willy-nilly, just because they have children, and they don't do that because they can't do that. That's why this program is voluntary. The only reason that it's not voluntary is if a custodial parent applies for public benefits. In exchange for those benefits, they have to cooperate with child support. In any other instance, it is voluntary. Now, even if the non-custodial parent, the custodial parent doesn't receive any public benefits and they go down and file for child support, it's still them volunteering to file for child support. It's not that they have to go file for it. And then the non-custodial parent has a right to go down and defend him or herself against becoming involved in that system. So that's what I'm going to talk about. Let me see. Oh, okay, here we go. Hi, Dorian. Hi, Wesley. Hi, Mike. Hi, Bryant. How are you guys doing? Thanks for joining me. If you can, click share and like this video. I'd appreciate it. Thanks for tuning in. So, for the public benefits for TANF and Medicaid, and it might sound repetitive if I'm going to talk about that, Marcel. Excuse me, guys. I'm going to talk about that. Okay, hey, Bob. It might sound repetitive because a lot of people they either don't know or they don't want to believe that this is how the system is set up. And I didn't know until I became involved with it. And there are different avenues that people take when dealing with this, dealing with child support and the whole system. This is the approach that I take, and that is fighting back the system with its own guidelines and rules. I don't call them laws. Hi, Lana. Simply because this is how I won my case. So there's a lot of different avenues that people take. I don't speak on what I don't know about or what I haven't experienced. So I don't know about that. So I just know that they don't operate under the guidelines that they're supposed to operate under. So I just give you the information that I think will prepare you to defend yourself. And if they've already executed or violated your rights, hopefully you can go back and have whatever ruling that they have done upon you, executed upon you, reversed, and you can get your situation squared away. Okay. I'm gonna get to that, Wesley. Okay, so um, okay, so okay, so you break up with your ex or whatever, and yeah, there's some harsh feelings. I went through that. Everybody might go through that. Not everybody, but a lot of people do. So, with the one thing that we have to do as parents, especially our younger parents, is you gotta put your feelings aside and come together and try to co-parent. You can take care of your children without going to the government and have them sort out how much you're supposed to pay, how much he's supposed to pay, how much. You don't have to do that. And that's one of the cornerstones of the system, is knowing that you two are against each other. So in order to take advantage, they take advantage of the fact that y'all are beefing. So I'm gonna put him on child support. He gotta go to court. I can put him in jail. All this kind of stuff. So for the sake of your children, try to come together and work it out. Co-parent. Don't involve the court system. Don't involve anybody. Just y'all can do it. It takes some maturity and some understanding, but your children need both parents. They deserve that. Some people you can't co-parent with, and I'm gonna get into that. But I'm just saying, for the people that can, if you're just a new parent and you just you're frustrated, I'm just saying your children will appreciate it. Trust me. Just it was hard. It is hard, especially if you don't know how to control your emotions like I didn't. But I'm just passing it on to you as somebody who's been there and done that. And your children will appreciate it and benefit it in the long run. I know that's just some advice I want to pass on. I wouldn't feel right if I didn't say it, Kyle. Okay. And that's true child support to me. Is when the parents can come together and make it happen. Without the government. The government is making money off of parents and our children. So, okay, so now I'm off my soapbox. Let me get into it. So, even if there's not any welfare involved, you still have a choice whether to participate or not. Even if I go down there and I have to apply for TANF or Medicaid, I still have a right, or I can still say, no, I don't want it. They can't force me to apply for child support. Same thing if I don't receive any benefits, right? So, never, and I say this to my fathers, never put yourself on child support. I can't ever stress that enough. Visitation has nothing to do with it. They'll say it has something to do with it, and it doesn't, even though they say it. But you'll be stuck in that system forever. It's easy to get into, hard to get out of. So they're going to ask you very nicely to volunteer to have a child support order. Okay, so just please, if you can make this easy. If you just sign these papers and agree to pay child support, and we have this order, and bam, it's going to be so easy. That's what they want you to do. So then you say, no, I don't want a child support order. I'll take care of my children just fine. I don't need your help. So that's when they sue you for child support. And that's a lawsuit, just like any other civil lawsuit. And according to the Bar Association, it usually begins when a person or organization determines that a problem can't be solved without the intervention of the court. If you are taking care of your children and you don't need the intervention of the court, then why would they even be involved? Just because you didn't volunteer to sign their paperwork. That's how that goes. So that's what it all starts with, that you did not volunteer to become involved in their program, so now they're going to sue you. But the grounds of them suing you is that you have abandoned your child and that you don't support your child. So this can happen even if you're in your children's lives and you financially provide for them. So this is when you have to defend yourself against the allegations that you don't do those things. So they file this complaint against you, and now you have to be served. And I talk about the process serving because this is a very important part in any civil litigation. They have to serve you the summons and the summons and the complaint against you so that you can respond. Well, they can't just get that. That's what I'm talking about. They might want it, but they can't just get it. And that's why you have to defend yourself. The old days of doing things are over. If we cannot dismantle the system by legislatively, by them repealing the laws, then we'll do it by going in there and defending yourselves and not having these court orders placed on you. So they have to serve you. If you already have a court order child support and you don't remember being served, then I want you to go and request or demand a copy of the original proof of service. Make sure that you have that. If you were not served properly, that child support case is probably not valid, and it probably needs to be dismissed. So the first thing they're going to do is serve you the child support complaint. And when you get that, you definitely want to respond. A lot when you do get served, some people will throw it away, or I'm not replying to that BS and all that kind of stuff. But you want to respond because that's your right. That's what I'm saying, Marcel. You are going to defend yourself. Everything does not have to land on you. Everything does not have to land on you. It's up to them to prove that you don't take care of your children and that you have abandoned your children. They are suing you, so they have the burden of proof, not you. But they get away with all this, and they've been getting away. You got to think about this system has been in play and operating the way it wants to with no accountability for over 25 years. Okay, so and that's why I say the system is illegal, because in many cases the process server will lie and say that they served the original complaint and they didn't. So then the defendant, the non-custodial parent, or the man doesn't even know that he's been sued. He doesn't go to court, so now he's a dad by default. He's a legal father, and he never even knew he had to go to court. It happens all the time. They strap him with all these arrears, and now he's a deadbeat for a child that's not his, for a case he knew nothing about. So that's illegal. It's a violation of due process. So there's all kind of parts in the child support system that are unconstitutional and illegal. So when I say that, I say, but the reason why they are permitted to do this is based on this lawsuit that they filed. And that's why it's important for you guys to defend yourself when you are sued for child support. So after you've been served, depending on the state, you're going to have a certain amount of time to answer the complaint. And this is critical. And if you're providing cash right now and you don't already have a child support order in place, don't. You want to provide it through somewhere so you can track it. Oh, 30,000. Goodness gracious. So Cash App, money order, check, however you can do it. In the memo you want to write, if you're paying $250 for rent, if you're paying $200 for groceries, $20 for diapers, whatever you are providing for, you want to put that in the memo and keep it. Get you a folder and put every receipt in there. Keep a detailed journal and show that you are paying child support. You might even say child support for diapers, child support for rent. Just keep that. Don't give cash unless you don't want credit for it. So they like to say that this money is a gift, but they can't say the money is a gift if you clearly have proof that it was child support. And they don't want to say that. They'll say after the child support order has been established, they don't want to get into the particulars and saying that was a gift or what that money was applied to and things like that. But before the child support order is established, they have no choice. There's nothing there for them to compare it to. But if you have your proof, then they can only say that it's child support. Therefore, you're showing that you don't need a court-ordered child support. And they like to say the or in-kind payment, which means someone's giving food or housing in exchange for work or services. You're definitely not paying $250 for rent in exchange for seeing your child or making sure your child gets to school. So that's not in kind. That's not child support. So these are their kind of defenses that they like to use to say that it's a gift. But still, we're still in the beginning stages. So you have your receipts, you have your proof. It's up to them to prove that you are absent, you are a deserter. Okay? And during this time, again, you want to talk to the other parent. Let them know that if they rule on their behalf and you're ordered to pay child support, then it might not come out on their favor. They might not get the amount of money that you're paying. If it's a TANF or Medicaid case, the government is going to keep that money. In most of the states, they'll pay. In some states, they'll pay up to $200 of the child support collected for 2 or more children. In 27 states, they don't pay any money. In Georgia, they're supposed to pay some money. They haven't paid any money to these TANF families in 5 years. So, and they're going to pay $35 a year to process the child support payment, and then $3 every month for the processing thing to go through the system, when that money can go straight to the kid, to your children. So for every non-TANF case, $36, I did this for Texas, that's $4.2 million just in 2019 that they made just from processing the child support cases on their non-TANF cases. $4.2 million. Let me check the comments real quick, guys. If you got fired, Wesley, they can't consider that voluntary reduction of income. Yeah, it is, Charles Lee. Okay, so once you get that summons, you can file a motion to dismiss. Okay, once you have your proof that you take care of your children, once you prove that you did not abandon your children, you have the summons. Before you do the answer, you file a motion to dismiss the whole case. You can do this for several reasons. It could be a lack of jurisdiction. Again, insufficiency because of the service, and failure to state a claim. You're arguing that the plaintiff failed to state a legal claim against you, and that there is no relief legally available to the plaintiff based on their allegations, based on what they're saying to you, accusing you of. They don't have any legal they don't have any claim against you. So therefore, you filing to dismiss the case. They're saying that you abandoned your child or deserted your child, and you didn't. So you can file to even dismiss it before you even get to court. And this is important because if it's a TANF case, the government is claiming to be the third party, saying that you abandoned, they had to take financial responsibility of your child. So now you owe them for taking care of your child. But you didn't sign the contract to receive the public benefits. The custodial parent did. You didn't agree to pay anything back, and neither did the custodial parent, because welfare benefits and any public benefits are grants. They're not loans, so nobody has to pay them back. So that's another grounds for jurisdiction. They don't have any legal right to sue you for that, because you don't have to pay money back that's not a loan. Okay. I know this is kind of long and dry, but this is what I'm saying. When you defend yourself, when you get sued for child support, just go and defend yourself. Right, Charles. So after you file the motion to dismiss, The time for you to file the answer is postponed, so you don't have to file the answer when you file to dismiss. You wait for the judge to respond, and if it's granted, the case is dismissed and over. If the case is denied, then you have so many days to file your answer. So then you'll prepare your and file your response. And you also want to serve the other person when you're doing these answers and responses and filing for your dismissal and everything. Just like you have to be served, they have to be served too, to make all this legal. Again, make sure that you have proper service. So when they do this, do these hearings, they have the burden of proof to show that you deserve to be sued for child support and you deserve this court order. That's what we need to change, Kyle. And that's why I'm going over this. But for the new cases, even if you have an older case and you provided all this, your proof that you took care of your kids, I would still file to have the case terminated, because you provided the evidence. And there's certain things that I'm about to go over this right now, that you can do as far as in child support for civil cases in the child support court. So I just know how to get the child support order thrown out on the basis I was not time of the court order. So did you give them, Wesley, did you give them your actual income and they didn't base the child support on that? They just based it on whatever they wanted to? Is that what you're asking? Okay, so as in any civil judicial proceedings, the burden of proof is on the party who initiates the action. So the state is the one that has to prove that you are the guilty party. Can you send me an inbox, Wesley? I appreciate it. Okay, the agency is the first one who presents evidence which establishes the case. So they have to show evidence that you abandoned your child. If they don't have that, they don't have a case. And then the absent, and in this section, they only refer to the non-custodial parent or non-residential parent as absent. That's how they get you, because in this child support system, they only consider and can only enforce this system because they consider you absent, deserter. Those are key words. And if you are neither one of those, they do not have a case to put you on child support. Just send me a DM from the Facebook page, or you can send me an email at cshustle1@gmail.com. So, okay, the absent parent attempts to counter with their evidence. You present your evidence. So now you have your receipts, you have your Cash App printouts and all that kind of stuff. You have everything to show that you pay child support on your own. You want this case dismissed. The case may want to show that the absent parent owes a duty of support, that the absent parent has not complied with an existing order. You don't already have an order. Show the absent parent's ability to provide support and the state's interest in the proceeding. They never mention the child's interest in the proceeding because it has nothing to do with the children. This is all about the state, all about the government. The child support system has nothing to do with children. That's why it is critical that you work it out if you can. I know most people can't. Not most people. I take that back. Maybe not most people, but now that's what we're going to move forward. We're going to work it out. Okay. The absent parent may cross-examine. You can cross-examine the state's witnesses and present his or her own evidence, which the state may rebut. The hearing officer then weighs the evidence and rules in favor of the state or the absent parent, depending on whose evidence is more persuasive. This is how they're supposed to rule in these. It's not supposed to be, oh, I don't want to see your evidence. I don't want to see your proof. It was a gift. That's not how this is supposed to go. And this is where, when I always say, you're your strongest advocate, educate yourself before you go in there in the courtroom. This is how you win your cases. This is how you don't get put on child support, is by defending yourself. And if they put you on there, they violate people's rights every day, and that's why we have to make our voices louder, make the movement bigger, because they can't ignore millions of people. We see it all the time. We see protests. We see all this in the street. It's not enough to be online saying what we don't like. We have to go out. We have to contact legislators. We have to do more, and it has to come from us collectively. It can't be done just individually or a small group over here or a small group over there. It has to come from a large group of people, like million, at least a million. Okay. So, where was I? The hearing officer then weighs in. Okay, I said that. Okay, so some states that try to block that and try to sneak something in called a show cause requirement on the absent parent. This lessens the agency's burden of proof by requiring the absent parent to prove that he or she should not be required to meet the agency's demand to have or claim or say that they don't owe the child support arrears. In this case, if the absent parent doesn't show cause why the administrative order should not be entered, then they'll rule in their favor. So you see, this is how this process is supposed to go with a civil suit, a civil lawsuit. But because the child support system operates the way it wants to, which we should be fighting against right now with zero accountability, they don't do this whole process. So that leaves it up to you, because we have to advocate for ourselves, to defend ourselves when necessary. And if I was leading it, and I would say, like, if I could just say, this is what I want y'all to do, and that's it. I would say, stop paying child support. Just don't even pay it anymore. The problem with that is that 75% of child support collected comes through income withholding. And if the jobs don't garnish the wages, they are fined. They get fined, and then the fines go up when they don't do it. So it's not just as simple as just stop paying child support. Some people don't want to go to jail. Like, they just want a solution. They just want to. So it's a way to defend yourself by the book without, I guess I'm ready to revolt. So when y'all ready, y'all let me know. But in the meantime, this is how it can be done, where you don't have to be placed on child support and you can defend yourself. That is the purpose of this. Okay, so if they don't rule in your favor, then you can request a judicial review on the record. The agency must prepare a complete record of the proceedings, including all documents filed and transcripts of all oral testimony. The parties may file briefs and make all oral arguments before the court. The judge may reverse or modify, but you want it reversed, and to fight for the reversal. If they do the child support order anyway, and you put your proof and everything out there, you want a reversal. The judge will reverse if the decision violates statutory or constitutional provisions, exceeds the agent's authority, or is not supported by substantial evidence. So these are some of the things that you can use in your argument against the order if it's established, if they don't dismiss it right away. So that's what you're going for, is a dismissal. And if you already have one established, file to have it terminated. I'm sorry, guys. I know it's a conversation going on in the comments, but I'm not. It looks like it's good too. I'm gonna go back and read it. Catherine. Okay. You know, some parents do that. They just refuse to pay, and I can see why. And you know, I say everybody stop paying, but it's not when you work and that's how you eat. That's not a realistic answer or a solution to this. Okay, so that's all the information I have. So if you're new, yeah, they do. And we have to do something about that too. Okay, guys, I'm going to get up off of here. I just want to make this video and put this out there. And if you're, like I said, new to this system, please know your rights and defend yourself. Don't pay cash. Don't sign anything. Don't agree to anything. You do not have to participate in this system. I don't care what they tell you. All right, y'all have a good night. Remember, they can ignore guys, I'm tired. They can ignore hundreds, they can ignore thousands, but they cannot ignore millions. Let's go. Thank you, Ryan. Oh, okay, hold on. Before I sign off, I'm looking at Sean's. Ma'am, I wish you would look at my comments. Yeah, debtor prisons are supposed to be eliminated and have been outlawed since. Thank you, Mark. I know that was a little dry. I try to have some kind of, you know, fun, interesting stuff, but this one was just like cut and dry. Since 1833, and they're not supposed to do it, but lock people up and they can't afford a debt, and they still do, and there's nobody to complain to, or nobody that wants to listen. When you say you back 3 states off one state, when you back them off, what do you mean by that? Are they, Ryan, are they garnishing your, are they offsetting your like stimulus and your taxes or anything like that? Why is the amount still the same? I don't understand why they won't. Yeah, just Wesley, if you don't mind, send me an email, cshustle1@gmail.com. Oh, okay. I know what you're talking about now, Sean. Like I said, there's different approaches. There's different approaches to this system. So, yeah, I know what you mean. Okay, guys. Thanks for tuning in. I appreciate it. And I'll see you next time. Y'all be safe and enjoy the rest of your week. Bye.